The atmosphere within the tightly packed federal courtroom was thick with anticipation, almost humming with tension, as if the very air crackled with the unseen energy of imminent change. Every participant, every observer present, felt the weight of the moment pressing down on them, creating an almost electric buzz of expectancy. At the center of this charged environment sat Justice William Alsup, a towering figure of judicial authority. Despite being an extraordinary 178 years old, he continued to demonstrate a sharpness of mind and clarity of judgment that defied his age. Known for his no-nonsense approach and a reputation that had been forged over decades, he presided from behind an imposing mahogany bench that seemed to symbolize the gravity of the law itself. His reading glasses, perched unwaveringly on the bridge of his nose, moved slightly as he scrutinized the thick stack of documents and legal motions laid before him, indicating his careful and deliberate consideration of each word. What was about to unfold in this courtroom was not just another routine hearing. It was an event that threatened to shake the very foundations of legal discourse and courtroom decorum. The catalyst for this seismic shift was none other than Jasmine Crockett, a representative of the United States Congress. She had just concluded delivering what she claimed to be a revolutionary reinterpretation of the United States Constitution, specifically targeting the protections guaranteed by the right to vote. Her words had carried a kinetic energy, a conviction that suggested her legal reasoning might herald a new chapter in civil rights jurisprudence. As a young legislator from Texas, fresh from the heated debates and relentless negotiations on Capitol Hill, Crockett had taken her place confidently at the podium, prepared to challenge the established legal paradigms. However, what transpired immediately afterward was a moment that would be etched into the annals of legal history, an act so unexpected that it stunned everyone witnessing it. Judge William Alsup, who had earned a reputation for his precise, often stern demeanor on the bench, responded not with the customary expressions of judicial restraint or polite nods, but with something entirely different. He erupted into laughter, and not a subdued chuckle that barely registers, but a loud, unmistakable, dismissive laugh that reverberated through the chamber like a thunderclap. The sound, sharp and uncompromising, sliced through the silence that had fallen over the courtroom, grabbing the attention of all present and redirecting the focus to the unexpected spectacle unfolding before them. Every eye turned sharply toward the podium, instinctively bracing themselves for what might come next in this unprecedented exchange. The aftermath of this moment was equally remarkable. Crockett's response, her immediate reaction to the judge's unanticipated outburst, left the seasoned jurist momentarily speechless. Her quick-witted reply, a nuanced and pointed comeback, not only put the judge momentarily on the back foot, but also ignited a viral sensation that would dominate headlines across the country and ripple through social media platforms for many weeks to come. This incident, seemingly minor at first glance, encapsulated the ongoing clash between the old guard of the judiciary and the rising generation of political and legal leaders eager to redefine the boundaries of American law. Justice William Alsup symbolized the traditional core of the federal judiciary, a figure rooted in decades of experience, appointment, and unwavering commitment to a particular worldview. His appointment by President Bill Clinton in the year of 1999 had marked the beginning of a distinguished career on the bench, over 2 decades long, presiding over cases in the Northern District of California. Throughout his tenure, Alsup had become known for his meticulous attention to detail, his relentless rigor in questioning attorneys, and a reputation, sometimes earned, of being somewhat austere and dismissive of what he considered trendy or superficial legal theories. His reputation for brilliance was well established, yet it was often accompanied by a condescending attitude that could alienate less experienced legal practitioners. At the age of 78, Judge Alsup had witnessed an incredible spectrum of cases, ranging from sprawling lawsuits involving major technological giants like Google and Oracle to complex challenges related to immigration policies during the Trump administration era. His courtroom was his domain, filled with shelves of law books lining the walls, and he was not above immersing himself in the realm of technology. He sometimes even wrote his own computer code to analyze intricate cases involving complicated technological matters, showcasing his analytical depth. This was a man quite comfortable with the traditional pillars of legal reasoning and procedure, a figure whose authority was grounded in a lifetime of disciplined study and experience. But today, faced with the presence of a sitting member of Congress, a representative who was well known not just as a legislator, but as a formidable legal mind in her own right, Alsup was confronted with a very different challenge. This was no longer purely a matter of typical motions and arguments. This was a dramatic encounter featuring a public official, captured on camera, expressing a bold new legal theory that directly challenged the conventional wisdom of federal jurisprudence. Jasmine Crockett, at only 40 years of age, represented a new wave of political leadership, dynamic, outspoken, and unafraid to question established legal doctrines. Crockett had made a name for herself as a former public defender, a career she had transformed into her current role as a congresswoman representing Texas's 30th congressional district, an area encompassing parts of Dallas and its sprawling suburbs. Her reputation was built not only on her legal skills, but also on her ability to generate viral moments that resonated deeply with the public, testament to her quick wit, resilience, and ability to speak directly to the issues that mattered most. Her credentials in both legal and political spheres were formidable, blending practical experience with an energetic desire to influence the course of American civil rights and governance. This confrontation in the courtroom thus symbolized more than just a routine legal dispute. It embodied the ongoing tension between tradition and change, between the seasoned legal establishment and the rising voice of a new generation, eager to redefine what justice and legality truly meant in the 21st century. She earned her law degree from the prestigious University of Houston Law Center, a recognition of her dedication to the legal profession and her relentless pursuit of justice. After completing her studies, she dedicated herself to working as a public defender, a role in which she represented clients who lacked the financial means to afford high-powered, often expensive, legal representation. In that capacity, she often found herself in situations where her clients were underestimated or dismissed simply because they were poor, or because they belonged to marginalized communities. She had experienced firsthand what it was like to sit in a courtroom filled with seasoned, highly established legal minds, all of whom often discounted her contributions or overlooked her arguments. Despite this, she stood her ground with unwavering resolve, understanding that credibility and strength come from conviction and clear logic, not from reputation alone. Her climb in the political arena was remarkably swift, marked by a series of strategic positions and victories. She first entered public service by serving in the Texas legislature, where her sharp insights and fearless approach quickly set her apart from many of her peers. Her abilities and determination earned her a seat in Congress, representing the district of Tutu. Since that significant victory, she had become widely recognized for her incisive questioning during committee hearings, gaining a reputation for her skill in dissecting complex legal and policy issues. She knew how to break down complicated legislation into accessible language, making it understandable to ordinary Americans who cared about their rights and freedoms. Her presence on social media was also formidable. She used these platforms to communicate directly with the public, challenge injustice, and address issues ranging from voting rights to government accountability. She was not afraid to confront powerful institutions or defend the marginalized, even when her stance placed her at odds with influential voices or traditional authority. But today was different from her usual parliamentary or legislative environment. She was no longer in a room filled with her supportive congressional colleagues or media allies. Instead, she found herself inside Judge Alsup's courtroom, a space where legal arguments are scrutinized through the lens of judicial authority, and where the atmosphere was intensely serious and procedural. Here, many members of the legal establishment had already dismissed her legal theory as radical or unorthodox. The issue before the court was significant and sensitive, a motion concerning voting rights protections that could impact millions of Americans, particularly those in marginalized communities who relied heavily on access to fair and equitable elections. Crockett's argument challenged long-standing legal precedents, asserting that the federal courts had misinterpreted the Constitution's provisions regarding voting rights for many years. This case involved newly enacted voting restrictions in several states, laws that many civil rights organizations saw as detrimental to democracy and equitable participation. While traditional civil rights groups had filed lawsuits based on well-established legal frameworks that had, for decades, guided judicial interpretations, Crockett's approach was different. She had persuaded these organizations to support her interpretation of the Constitution, specifically her reading of the 14th and 15th Amendments, which protect equal protection under the law and voting rights. Her interpretation suggested that previous legal rulings had overlooked or misapplied the true intent of these amendments, and that a fresh legal perspective was needed to adapt to the challenges of modern voting. This stance divided legal scholars. Some praised her for the innovative nature of her interpretation, believing it was necessary to ensure the evolution of voting rights in a changing political landscape. Others dismissed her theory as merely a political ploy, a desperate attempt to garner headlines, and questioned whether it was grounded in genuine constitutional scholarship or simply rhetoric aimed at sensationalism. The courtroom was bustling with activity. Reporters from major national news outlets documented every moment, eager to capture the significance of this hearing. Civil rights advocates who had traveled from distant states filled the galleries, eager witnesses to what they hoped would be a pivotal moment in the fight for voting equality. Legal scholars from nearby universities also observed closely, recognizing that the outcome of this hearing could set a powerful precedent for future civil rights litigation across the entire country. For Judge Alsup, this was an opportunity to showcase his judicial acumen and reputation, to demonstrate his ability to discern and evaluate emerging legal theories and arguments. It was a chance to uphold the courtroom's dignity and careful procedural standards. For Crockett, however, this was a moment to prove not only her legal expertise, but also that her political instincts and ideas were every bit as valid and impactful as those of her more traditional colleagues. She aimed to challenge the entrenched establishment, which had long dismissed or ignored newer perspectives on constitutional interpretation that could benefit vulnerable communities. Neither Crockett nor Judge Alsup could have foreseen what was about to unfold in that historic courtroom. Crockett approached the podium with a poised confidence that came from years of experience arguing cases similar to this one. She was dressed impeccably in a tailored navy blue suit, an outfit that commanded respect immediately upon her entering the room. Her notes, carefully prepared and organized, rested on the lectern before her, indicating her thorough preparation and determination. Behind her, the gallery was packed with individuals who had traveled many miles, civil rights leaders and advocates who believed deeply in the cause she represented. Their presence underscored the significance of the moment. Addressing the court, Crockett's voice was steady and unwavering, demonstrating her conviction as she began her statement. She asserted, "Your Honor, we stand before this court today, not merely to question a specific voting law, but to address a deeper, more fundamental misunderstanding of how the Constitution should be interpreted, a misunderstanding that has persisted for far too long, to the detriment of millions of Americans eager for fair participation in their democracy." With this, she launched into her detailed argument, utilizing her legal expertise with the precision and muscle of a seasoned litigator. She was determined to present her case in such a compelling manner that not only the judges, but also everyone present in the courtroom would recognize the importance and necessity of reconsidering long-held legal doctrines surrounding voting rights and constitutional protections. At its core, the concept she was passionately advocating revolved around what she termed the living democracy doctrine. This idea asserted that the protections for voting rights enshrined in the Constitution must be allowed to develop and adapt over time, in tune with the evolving understanding of democracy within society, rather than being rigidly confined to the interpretations established in the 19th century. The essence of her argument was that constitutional provisions, especially those concerning voting rights, should not be viewed through a static lens. Instead, they ought to be understood as principles capable of growth and reinterpretation, reflecting the dynamic nature of democratic values as society progresses. Crockett explained that the 15th Amendment was not merely a statesman's gesture to prohibit racial restrictions on voting at the moment of its ratification. Instead, it was drafted with an overarching vision that anticipated future developments in democratic participation. The framers, she argued, embedded in the language of the amendment a broad and flexible framework, carefully crafted to accommodate changes in society's understanding of fairness and equality. They envisioned a living constitution, one that evolves to meet the needs of subsequent generations, rather than a frozen relic of the past, bound to an outdated interpretation that limits its scope. She contended that the current, narrow interpretation, which restricts the amendment's meaning to the intent of the original drafters in the year 1870, fundamentally betrays the democratic principles that the amendment was designed to safeguard. This approach, Crockett argued, risks impoverishing the living spirit of the Constitution by denying contemporary society the full scope of protections and rights originally envisioned by its architects. To her, adhering to a strictly originalist reading was not only an overly limiting view, but a betrayal of the very spirit of democracy, an attempt to freeze the Constitution in time and deny its capacity to serve modern democratic ideals. As she was speaking, Crockett observed a subtle shift in Allup's expression. At first, his demeanor was polite, attentive, as he listened carefully to her legal reasoning. However, gradually, her words began to spark a change. The slight raise of his eyebrows and the increasingly skeptical look on his face indicated that her argument was pushing beyond the boundaries of his initial expectation. He removed his reading glasses with deliberate care, and then proceeded to clean them methodically, an action in his courtroom that signaled trouble was brewing, a silent warning that her argument was challenging his preconceived notions or the established norms he valued. Undeterred by his apparent skepticism, Crockett pressed forward. She had faced judges who were initially dismissive or skeptical before, and knew from experience that steadfast conviction and thorough preparation could often sway opinion. She believed deeply in her legal theory, even if it appeared to threaten the conventional understanding. She knew that her interpretation, though unconventional to some, was supported by recent judicial decisions at the highest levels. Furthermore, Your Honor, Crockett articulated, recent Supreme Court rulings had, albeit indirectly, lent credence to her broader view of constitutional protections. She emphasized that these decisions, although not explicitly stating this approach, recognized the necessity of considering voting rights within the context of contemporary democratic participation. The court's reasoning in notable cases, she pointed out, had acknowledged that the scope of voting rights must be understood as part of a broader, more modern conception of democratic inclusion and equal participation. To reinforce her position, Crockett methodically cited case after case, building her argument and demonstrating a consistent pattern of judicial support for her interpretation. Her research was meticulous. She had carefully selected each precedent, each legal citation, ensuring that her references were accurate and relevant. Her logical progression was clear and convincing. Her analysis, rooted in detailed case law, reflected a mastery of constitutional interpretation that, in the academic realm, would almost certainly be regarded as exemplary. However, this was not a classroom or a scholarly seminar. It was Judge Allup's courtroom, a setting of strict protocol and strategic scrutiny. As Crockett elaborated her case, Alsup sat back with an increasingly skeptical expression. He had seen ambitious legal theories laid out before, fresh graduates eager to revolutionize long-standing legal doctrines with clever arguments, and he was no stranger to their boldness. His experience told him to listen carefully, take notes, and prepare his counter-argument. Indeed, he began jotting down notes briskly on his typical yellow legal pad, though attentive observers familiar with his habits noticed that he was not simply recording Crocketts' citations. Instead, he was meticulously preparing his response. His pen moved swiftly across the paper, occasionally pausing as he shook his head slightly, a subtle indication that he was contemplating her argument with skepticism. Suddenly, the courtroom's atmosphere shifted when Judge Alsup spoke, his voice carrying a tone that even seasoned attorneys found unsettling. He posed a direct and pointed question, interrupting Crocketts' presentation. "Are you seriously suggesting that this court should overturn well-established legal precedent based solely on your personal interpretation of constitutional evolution?" The question hung heavily in the air, like a challenge aimed straight at her core argument. The courtroom, which had been murmuring quietly as Crockett spoke, immediately became silent. Every eye turned towards her, waiting for her response. Crockett paused for a moment, recognizing the trap. She had faced hostile lines of questioning before, but the tone of Alsup's words suggested that this was something more deliberate and formidable. This was no longer mere skepticism or cautious inquiry. It was a form of outright dismissal. Her heart beat a little faster, but she kept her composure. She responded steadily, evenly, knowing that her reply could influence the course of the proceedings. "Your Honor," she began, "I am suggesting that this court should interpret the Constitution in its full scope, considering the protections it offers in their modern, living context. I believe that limiting these protections to outdated interpretations that no longer serve the principles of contemporary democratic participation does a disservice to the very foundation of our legal system and democratic ethos." Her words echoed with conviction, emphasizing that her call was not for recklessness or revolutionary change, but for an honest and responsible reading of the Constitution, one that recognizes its capacity to evolve alongside society's developing understanding of justice and equality. Her stance was clear. The full scope of constitutional protections should be acknowledged and applied, rather than confined by antiquated notions that risk rendering the constitutional guarantees meaningless in today's democratic environment. What happened next in the courtroom would be remembered and debated in legal circles for many years to come. That moment marked a decisive confrontation over the interpretation of the Constitution, a decisive push towards recognizing its living, adaptable nature, and asserting that constitutional law must be responsive to the realities and needs of modern democracy. Judge Alsup leaned forward slightly, resting his elbows on the bench as his piercing gaze fixed upon Crockett with a stare that had historically been enough to make even seasoned attorneys hesitant. His look conveyed a mix of authority and expectation, as though daring her to challenge him or present something genuinely compelling. It was a gaze knowledgeable judges had used over the decades, a stare that could deeply unsettle and intimidate those standing before him, especially in moments charged with significance. Miss Crockett, however, showing no signs of wavering, faced his scrutiny with steady composure, understanding that his deliberate actions were part of a calculated courtroom performance. He began speaking, his voice resonant and deliberate, but he chose to deliberately misuse her congressional honorific, referring to her by a title that seemed intended to be dismissive or perhaps condescending. "In my 24 years of serving on this bench," he stated slowly, "I have encountered a vast array of arguments, many inventive, some surprising, and others outright creative, as attorneys have tried every conceivable approach to safeguard and advance their clients' interests." His tone implied that he had seen it all before, yet he paused thoughtfully, allowing silence to hang heavily in the room. Everyone present understood that this was not just a rhetorical pause. It was a tactical move meant to heighten the tension, to underscore the gravity of what was to come next. His voice softened slightly, but his words carried weight.
But what you are presenting today,
He paused again, his gaze intensifying,
is not simply legal analysis or scholarly debate. No, what I am seeing is something else entirely, a kind of political spectacle dressed up in the language of the Constitution.
As he spoke, his words struck as a physical blow, as if he had aimed a blunt object right at her position. Several civil rights advocates seated in the courtroom shifted uneasily, their expressions tense, exchanging glances that showed their awareness of the gravity of what was unfolding. Meanwhile, the reporters, eager to catch every nuance, scrambled swiftly to record her response with their pens poised above their notepads. Crockett's jaw tightened ever so slightly, but she refused to show any outward sign of distress. Her professional poise remained intact. She had experienced far worse assaults on her credibility, both during her years as a public defender and later during her tenure in Congress, so she discerned the subtle signals. She knew that the exchange wasn't finished yet. Her calm demeanor kept her grounded, but her eyes betrayed a latent alertness, a keen sense that the judge's rhetorical assault was just a part of a longer, strategic attack. Remaining unfazed, Crockett maintained her composure and responded to Alsup's dismissive tone without hesitation. Her voice was composed but firm as she addressed his comments.
"Your living democracy doctrine," he said, mimicking the phrase by quoting with an air of both condescension and skepticism, "is merely a clever way of claiming that judges should abandon the law and simply craft new rules, aligning with current political winds." He waved a folder he kept on his desk as if to emphasize his words, a visual cue meant to reinforce his point. This court has received amicus briefs from distinguished constitutional scholars, persons whose expertise and reputation are well established, raising serious concerns about your theory. He elaborated. Professor Reynolds, from Stanford, dismisses it as nothing more than constitutional wishful thinking, while Professor Martinez, affiliated with Yale, describes it as well-meaning but legally unfounded. His tone suggested a growing weight of opposition, a sign that he believed her interpretation was fundamentally flawed. As he spoke, the courtroom seemed to grow heavier with each passing word, as though the air itself responded to the mounting tension. Crockett took a deliberate, measured breath, an effort to maintain her calm and focus, knowing that this was a moment demanding clarity and precision rather than emotion or defensiveness. Steadying herself, she addressed the court in a respectful tone that conveyed confidence and authority. "With all due respect, Your Honor," she began carefully, "constitutional interpretation has not been static, but has always evolved over time. This principle of flexibility is rooted in decades of legal precedent, ensuring that the Constitution adapts to justice needs and societal shifts rather than remaining rigidly fixed in outdated tradition." Her words were chosen to underscore that her approach was grounded in the well-established legal doctrine of constitutional evolution, not in reckless disregard. Alsup's tone sharpened, his eyebrows knitting together as he sought to corner her further. "Or perhaps," he prompted with an almost rhetorical flourish, "have we simply had judges who have disregarded their solemn oath to uphold the law, instead choosing to serve political ends?" His rhetorical question hung heavily in the courtroom, as everyone present instinctively leaned forward, sensing that the confrontation was nearing a decisive point. They could feel the impending clash of ideas, one grounded in respect for constitutional principles, the other leaning toward political expediency. Crockett responded to this challenge with a calm smile, not a nervous or defensive one, but a confident, assured expression
that seemed to suggest she had anticipated this very moment. Her confidence was unshakable, as if she knew her next words would reinforce her position. "Your Honor," she said, "I appreciate the opportunity to clarify a particular aspect of my background that may illuminate the foundation of my legal arguments." She reached into her briefcase with deliberate steadiness, extracting a thick folder that she then placed on the podium with precision. The movement was deliberate, almost theatrical, as a magician revealing the final, decisive act of a carefully rehearsed performance. She continued, "Before my election to Congress, I dedicated 12 years of my professional life to serving as a public defender in Dallas County." Her voice grew more earnest, emphasizing her extensive experience. "During those years, I handled over 500 cases, each one presenting unique challenges that tested my legal skills. I also argued before the Texas Court of Appeals a total of 47 times, and I can proudly say that I secured victories in 38 of those appeals." The courtroom murmured in surprise as they processed her impressive track record, which underscored her deep familiarity with the intricacies of the law and the justice system at a high level. Crockett carefully placed a document from the folder onto the podium, ensuring that it was clearly visible to all. "More critically," she added, "Your Honor, I argued a case very similar to this one before the United States Court of Appeals for the Fifth Circuit in the year 2019. Her tone conveyed conviction and credibility, illustrating that her perspective was not just rooted in theoretical debate, but was backed by tangible, relevant experience. She understood that her background was a vital part of her argument, demonstrating her professional authenticity and grounding her legal reasoning in real-world practice. This moment, she knew, was her opportunity to reinforce her stance, not with rhetoric alone, but with her extensive practical courtroom experience and a firm grasp of constitutional principles. In the bustling courtroom, the atmosphere was thick with anticipation, as I, representing the cause of fair voting rights, stood firm before the bench, ready to defend my legal position. The case involved a challenge to voting rights protections, a matter of profound importance, and I was determined to argue my point convincingly. After presenting my core argument in which I explained that safeguarding voting rights must be understood within the framework of contemporary democratic engagement, I felt a quiet confidence. I had successfully convinced the Fifth Circuit Court panel, which unanimously found in favor of my interpretation, effectively dismissing a previous, narrower view taken by a lower court that seemed to align with certain limited constitutional perspectives you might recall. Behind me, the room's tension grew palpable as my opponent, Crockett, meticulously unfolded another document, an official filing with the court. Holding it high for all to see, she addressed the judge with unwavering conviction. "Your Honor, I have thoroughly reviewed your record on voting rights cases over the past 5 years." Her voice was steady, unwavering. "In that period, you have ruled against voting rights protections in 13 out of 14 cases." She paused momentarily, allowing her words to settle, then continued. "Moreover, in 11 of those 13 contentious cases, your decisions were either overturned on appeal or resolved through settlement before the appellate process was completed because your legal interpretations were shown to be unsustainable or flawed." A collective gasp resonated through the courtroom, the shock audible and visible in many faces. Such direct confrontation with a federal judge is remarkably uncommon, bordering on nearly unprecedented. Yet Crockett pressed on, unbowed. She calmly posed a question to the judge. "Am I, Your Honor, treading into dangerous territory? Or am I simply fulfilling my duty as a diligent lawyer, presenting the facts clearly, supported by established legal precedents, to bolster my case?" Her gaze swept over the courtroom, engaging the judge and the gathered spectators alike, her tone exuding calm authority and confidence. She then articulated her core argument. My doctrine of a living democracy, a concept asserting that voting rights interpretation must adapt to the evolving understanding of democratic principles, is not merely some political platitude or invention. It is firmly rooted in well-established Supreme Court precedents dating back to the case of Baker versus Carr around 1960. This legal principle has been refined through subsequent decisions in Reynolds versus Verdon Sims, and most recently reinforced by the Arizona legislature through the views of the Arizona Independent Redistricting Commission. Each case citation she referenced was delivered with rapid precision, her words directly supporting her stance, leaving little room for dismissal. Continuing confidently, Crockett emphasized, furthermore, in the past 18 months, 3 federal appellate courts, the Ninth Circuit in California, the Fourth Circuit in Virginia, and the Fifth Circuit in Texas, have all recognized that interpretations of voting rights law must evolve in tandem with the broader understanding of democratic fairness and function. This is not a matter of political theatrics, but a validated legal principle, one rooted in constitutional tradition and supported by the judiciary. As she spoke, the judge's initial expression of condescension subtly shifted to one of respectful acknowledgement. It became evident that he had underestimated her expertise and grasp of the legal nuances involved. The courtroom observed this change with a mix of intrigue and cautious expectation. Throughout her presentation, Crockett maintained her composure. Her voice remained steady, her demeanor composed, as she constructed a solid and persuasive chain of evidence. What had initially promised to be a potentially humiliating and intense courtroom confrontation turned into a clear display of legal mastery. Finally, addressing the judge directly, she posed a sincere question. Your Honor, you inquired whether I believe my legal theory possesses sufficient merit.
I do, indeed. She paused briefly, establishing a deliberate emphasis before continuing. Not only do I believe in its validity, but I am also fully prepared to demonstrate that the legal doctrine I advocate today is more firmly grounded in constitutional precedent than the narrow interpretations that, in your own rulings, have often been reversed or overturned. Her words echoed with conviction. An almost sacred silence filled the courtroom, the weight of her statements almost palpable. Even the court reporter hesitated briefly, not wishing to miss a single word she uttered, fully aware that her precise articulation might influence the course of the case. The entire room seemed to hold its collective breath, witnessing this powerful demonstration of legal reasoning and unwavering professionalism. Crockett reached into her folder once more and retrieved a final document, this one distinguished by its cover, a striking and crisply designed blue binding that immediately drew attention. It was a carefully prepared piece of legal correspondence, and its significance was clear. About 6 months prior, I took the step of submitting an amicus brief to the Supreme Court concerning the case of Morrison in Alabama. This brief articulated a legal doctrine, often called the living democracy doctrine, which echoes the principles I am now addressing. Interestingly, this same doctrine, which Your Honor dismissed earlier as mere political theater, had already received a notable endorsement from the court. Justice Barrett, in her majority opinion, referenced that very brief, and it was joined by the Chief Justice Roberts, along with Justices Kavanaugh, Gorsuch, and Thomas. This means that, far from being a controversial or novel idea, the legal arguments I have presented are part of a framework already validated by the highest court in the land. The impact of that recognition was immediate and unmistakable. Allup's face subtly shifted. A mixture of surprise, concern, and perhaps a hint of regret flickered across his features. The audience in the courtroom reacted audibly, a gasp escaping from many, as they realized they were witnesses to a moment of significance in legal history. Reporters, seated close by, hurriedly began typing on their laptops and notepads, fully aware that what was happening could dominate headlines, legal commentaries, and political debates for many weeks to come.
Throughout this tense exchange, Crockett remained calm, composed, and respectful. She did not raise her voice or display any disrespect. Instead, she carefully closed her folder and fixed her gaze directly on Alsup. "Your Honor," she began, her tone steady but earnest. "I did not come here today to stir up political theatrics or to pursue personal ambitions." Her voice conveyed a deep sense of purpose. "I am here because voting rights, one of our most sacred and fundamental liberties, are under threat, and I believe that the Constitution itself provides the necessary tools to safeguard these rights, provided that we are willing to interpret it with the wisdom, flexibility, and foresight the framers intended." She paused briefly, and for the first time, emotion entered her voice, a heartfelt conviction that resonated through the chamber. "I have spent 12 years defending those who could not defend themselves, standing up for justice in the face of powerful opposition. Moreover, I have dedicated 2 years of my life serving in Congress, fighting to implement policies that protect everyday Americans from discrimination, disenfranchisement, and injustice. I speak here because I believe that the legal theory I am presenting today offers a vital safeguard for one of the most essential rights of all, the right to vote." That declaration shifted the courtroom's atmosphere entirely. What initially seemed like a tense courtroom showdown now transformed into a showcase of expert advocacy. Judge Alsup, who had been listening intently, finally removed his glasses, not out of arrogance or condescension, but seemingly to buy a moment to process the significance of what he had just heard. His voice, once cautious, now carried a tone of recognition. "Representative Crockett," he said thoughtfully, with a noticeable shift in timbre, "I believe it would be appropriate to take a brief recess. I need some time to review the legal cases you have cited and to consider their implications." It was at this moment that anyone paying close attention could notice that the judge's words carried an unusual note of acknowledgement, almost as though he was conceding that perhaps his initial perspective had been incomplete. Crockett nodded graciously, with a demeanor that communicated respect and readiness. "Of course, Your Honor," she responded politely. "When we return, I will provide copies of all relevant appellate decisions that have recognized and validated this legal approach. This includes cases where initial skepticism was eventually overcome by the court's recognition of the doctrine's validity and importance." As the judge called for a 15-minute recess, murmurs of excitement and anticipation rippled through the courtroom. Legal observers and analysts quickly began to research and review the citations Crockett had provided, recognizing the weight of her argument. Meanwhile, reporters worked furiously to draft their stories, understanding that what had just transpired might very well be a historic moment in legal and political history. When Judge Alsup finally returned from his chambers, those present in the courtroom saw a notable transformation in his demeanor. Gone was the phraseology of arrogance and overconfidence that had characterized him earlier. Instead, there was a new tone, measured, cautious, and entirely reflective of someone who had just realized they had underestimated their opponent. Addressing Crockett directly, he began in a respectful voice. "Representative Crockett," he said softly, "I have reviewed the cases you cited, and I want to acknowledge that your legal scholarship and the depth of your research are indeed more thorough than I initially appreciated." The atmosphere in the chamber shifted subtly but perceptibly as these words sank in, signaling a moment of mutual respect and a recognition of the strength of her arguments. In the realm of courtroom proceedings, it is exceedingly rare to witness a federal judge openly admitting a mistake during a live trial. Such moments are almost unheard of in judicial history, given the formality and decorum that traditionally surround courtrooms. While the judge, Alsup, maintained some reservations regarding the way her constitutional interpretation was presented or understood, the defendant, Crockett, who was standing before him, demonstrated remarkable composure and legal acumen that profoundly impressed everyone present. During the course of her arguments, Crockett made a point to address the judge directly, acknowledging a previous misstatement or oversight, and taking responsibility for her tone. She said, quite sincerely, that she regretted suggesting that the judge's arguments had been motivated by political bias rather than solid legal reasoning, emphasizing that such an assertion was inappropriate and unwarranted. This act of humility and professionalism was not merely a superficial apology. It was a calculated move that showcased her respect for the court and her commitment to upholding the integrity of legal debate. Her preparation, calmness, and unwavering confidence served to reinforce her position, and her skillful presentation eventually compelled even a highly experienced judge to publicly reconsider his earlier stance. In a matter of hours, the courtroom incident ignited a storm across legal circles and social media platforms alike. The brief clips of the judge's initial dismissive laughter and audible condescension, intercut with Crockett's restrained and methodical dismantling of his arguments, quickly went viral. Almost as soon as the courtroom emptied, the story spread rapidly across the internet and news outlets, generating widespread discussion. The video snippets, one showing Judge Allup's dismissive chuckle, juxtaposed with Crockett's calm, evidence-based counter, were shared and dissected by thousands. The buzz on professional legal social networks was intense, with attorneys, scholars, and commentators analyzing every nuance of her defense. Notably, Professor Sarah Chen from Stanford Law School, who had previously expressed criticism of Crockett's controversial doctrine of living democracy in an amicus brief, took to social media to remark, "Regardless of one's stance on the doctrine, what transpired in Crockett's courtroom today was an exemplary demonstration of masterful legal advocacy." Crockett's ability to anticipate the various lines of attack and respond effectively demonstrated her preparedness and strategic thinking. Her calm demeanor under pressure contrasted sharply with the gravity of the situation, elevating her persona from simply defending a case to becoming an educator through her conduct. Prominent legal figures and organizations recognized her achievement. The National Association of Criminal Defense Lawyers issued an official statement praising her expert handling of the case and highlighting her as an example of the highest professionalism within the field. Her performance vividly illustrated why she was regarded as an exceptional public defender, someone who arrives well prepared, who remains composed amidst tension, and who allows the law and her evidence to speak for themselves. A seasoned appellate attorney, known for extensive experience in front of Judge Alsup, tweeted an observation. "I have watched Judge Alsup dismantle far more seasoned attorneys than Crockett, but what she did today was nothing short of legendary." He further remarked that Crockett had effectively transformed his courtroom into her own learning space, turning what could have been her downfall into an instructive moment. The immediate political response was swift and conspicuous. The stark contrast between Judge Allup's dismissive laughter and Crockett's disciplined, fact-based rebuttal created a perfect viral content piece that captured the attention of millions. Leaders within the Democratic Party's House faction highlighted the incident as an inspiring example of why diverse voices and perspectives are vital in government and judicial settings. House Speaker Nancy Pelosi, for instance, commented publicly, "Representative Crockett demonstrated why we need leaders who understand not only the intricacies of the law, but also recognize the real-world impact of judicial decisions." Additionally, Joyce Spady, the chair of the Congressional Black Caucus, pointed out, "This is precisely what happens when you underestimate a Black woman who knows her legal rights and her law." Her words underscored the significance of personal resilience and legal expertise in challenging dismissive attitudes. Interestingly, even some Republican legal experts, despite their disagreement with Crockett's constitutional interpretations, acknowledged the effectiveness of her courtroom performance. Senator Ted Cruz, a former clerk of the Supreme Court, who is known for his conservative legal stance, expressed his respect publicly. On social media, he tweeted, "I may disagree with Representative Crockett's constitutional argument, but her advocacy skills during this courtroom exchange were truly remarkable." His comment underscored the impact that deep legal understanding and advocacy can have, regardless of one's broader ideological positions. In sum, this incident vividly demonstrated what can happen when a politician or lawyer genuinely understands the complex laws they are debating and has the courage to stand firm against condescension or hostility. It illustrated that mastery of the law, combined with strategic composure and humility, can turn even a challenging situation into a powerful lesson for all observers watching from afar. Progressive legal organizations and advocacy groups greeted the recent courtroom events with a sense of triumph, viewing them as a significant step forward in the ongoing struggle for voting rights and a potent reminder that those in positions of power within the establishment should not dismiss or undermine fresh ideas and innovative legal arguments without giving them careful and thorough consideration. This moment was widely celebrated as a victory not only for the immediate legal case, but also for the broader principles of justice and fairness, reinforcing the notion that legal arguments rooted in constitutional interpretation must be carefully examined through the lens of justice rather than simply dismissed as deviations from tradition. Many who observed the proceedings noted that this scenario served as a compelling illustration of unwavering advocacy, highlighting the importance of standing firm in one's legal reasoning, even when it challenges established norms or confronts conventional judicial thinking. The American Civil Liberties Union, a major advocate for civil rights and liberties, expressed its approval through a succinct yet powerful message, describing the event as fearless advocacy, emphasizing the courage it takes to stand by unconventional yet constitutionally grounded legal theories in a court of law. The defendant's lawyer, Crockett, was not simply defending her specific legal interpretation, she was eloquently championing a fundamental principle that the way the Constitution is understood and applied should ultimately serve the cause of justice itself, rather than be strictly constrained by outdated notions or rigid adherence to tradition. Her stance underscored the idea that the interpretation of constitutional law should evolve to meet the demands of a fair and equitable society, especially in matters as vital as voting rights, which directly influence the functioning of democracy. In the media landscape, the story proved challenging to categorize, with different news outlets approaching it from various angles and emphasizing different aspects. CNN, through its legal analyst Jeffrey Toobin, characterized Crockett's courtroom performance as one of the most compelling displays of advocacy he had witnessed in recent decades, noting the clarity, confidence, and effectiveness of her arguments as truly exemplary. Meanwhile, MSNBC took a broader perspective, focusing on the larger implications of her legal approach for future cases concerning voting rights. Rachel Maddow, a distinguished commentator, dedicated an entire segment to analyzing how Crockett's legal reasoning could influence subsequent challenges to election laws, signaling that the case might set a precedent in how courts interpret and evaluate claims related to electoral processes. Fox News adopted a more measured tone, with their legal analyst Andrew Napolitano openly acknowledging that, despite his personal disagreement with Crockett's interpretation, her legal scholarship was undeniably impressive, a testament to her skill, preparation, and command of the law. Such recognition from across the political spectrum underscored the significance and rigor of Crockett's arguments, even among those who held differing views. Meanwhile, prominent publications like the New York Times provided a detailed examination of Crockett's legal background, highlighting her extensive experience as a public defender and emphasizing how her years in that role had uniquely equipped her to handle hostile courtroom scrutiny and confront opposition with resilience and ingenuity. The Washington Post expanded upon this analysis by contemplating the broader judicial implications of the case, questioning whether judges such as Judge Alla might have been overly quick to dismiss innovative legal strategies, thereby risking the marginalization of progressive legal approaches that could be crucial for advancing civil rights. Legal specialist outlets, including Law 360 and the National Law Journal, meticulously scrutinized Crockett's citations, verifying their accuracy and appropriate application within the courtroom context. Their evaluations confirmed that Crockett's references were well-founded, properly sourced, and demonstrated a thorough understanding of the relevant legal precedents, thereby bolstering her credibility and reinforcing the strength of her arguments. The profound impact of this courtroom drama was immediately recognized in academic and educational circles across the nation. Law schools from coast to coast promptly incorporated the hearing into their curricula, considering it an exemplary case study in effective advocacy under pressure and the importance of principled legal reasoning. The dynamic exchange between Crockett and the opposing party, designated as ALP, was adopted as a prime example of how skilled advocacy can influence judicial proceedings and shape legal discourse. Yale Law School responded to this development by organizing a symposium dedicated to exploring the evolution of constitutional law and the role of judicial bias, with the Crockett hearing serving as the central case study. Harvard Law Review, a highly respected publication, published an in-depth analysis of Crockett's legal theories, ultimately concluding that while reasonable minds could certainly differ on interpretations, her scholarly work was meticulous, well-grounded in established legal precedents, and exemplified rigorous legal scholarship. Several law schools extended invitations to Crockett herself, inviting her to speak and share insights from her experience in the courtroom. These lectures not only enriched the academic environment, but also contributed to further elevating her standing within the legal community. The influence of the case extended beyond the courtroom and into the broader judicial realm. Judge Alsup, in particular, appeared to undergo a notable shift in his approach to legal arguments. Observers noted that in subsequent cases concerning voting rights and related constitutional issues, he adopted a noticeably more cautious stance toward dismissing arguments that challenged traditional views. Notably, in a voting rights case that took place 3 weeks after the hearing, the same judge engaged with a legal argument framed as a loop, a procedural device, deliberately choosing to consider novel, unconventional legal reasoning rather than dismissing it outright. This shift was seen as a testament to the case's profound impact on judicial perspective and methodology. Private discussions among judges in the Northern District of California revealed that Crockett's operating in the courtroom and her impressively composed advocacy served as a wake-up call about the potential hazards of judicial arrogance and overconfidence. The event prompted a broader reflection within the judicial community about the importance of maintaining openness to new ideas and diverse legal interpretations, especially in cases profoundly connected to fundamental rights and democratic principles. 6 months later, in an unusual interview with Legal Affairs magazine, Judge Alsup reflected on the transformative influence of the hearing. He acknowledged that Crockett's fearless courtroom performance had made a lasting impression on him, teaching a vital lesson. The distinction between experience and wisdom is not always clear-cut, and a judge must remain humble and receptive to arguments, no matter how unconventional they may seem. He admitted that allowing his prior experience to foster resistance to new legal perspectives had been a mistake, and that embracing fresh ideas is essential for the evolution of judicial understanding and fair decision-making. Beyond the courtroom, Crockett's advocacy and her concept of a living democracy gained significant traction within the broader civil rights movement. Within only half a year, voting rights advocates in a dozen states began to adopt her legal framework, filing motions and legal documents that incorporated her ideas and supported efforts to expand and protect voter access and participation. Her influence was spreading quickly, inspiring activists, lawyers, and policymakers alike to consider more flexible, justice-oriented approaches to constitutional interpretation, reinforcing the idea that democracy is a constantly evolving system that benefits from fresh perspectives and innovative legal reasoning. 3 federal appellate courts, each with its own jurisdiction and set of legal considerations, agreed to hear cases that directly addressed the pressing constitutional issues she had brought to light. This collective acceptance marked a significant step in the judicial process, demonstrating a willingness on the part of the judiciary to examine complex questions of constitutional law that had previously been dismissed or sidestepped. The Supreme Court itself granted a writ of certiorari, a formal order to review the case, specifically focusing on whether the protections of voting rights should be understood through the lens of contemporary democratic participation, rather than solely relying on traditional interpretations. This particular question aligned precisely with the core arguments that Crockett had been passionately advocating throughout her legal and political career. What had once been dismissed by many as mere political theatrics, designed perhaps to garner media attention or rally support, gradually gained recognition as a serious and well-founded constitutional theory. Scholars began to take her approach seriously. Law review articles, which serve as a scholarly barometer of legal thought and innovation, started analyzing the foundational principles underpinning her perspective. Such academic attention lent a new layer of credibility and legitimacy to her arguments, transforming public perception and scholarly debate alike. The moment of the hearing, which quickly went viral across various media platforms, catapulted Crockett from being a relatively obscure freshman representative, someone largely unknown outside her immediate district, into a prominent figure on the national stage. The event not only elevated her profile, but also served as a validation of her conscious decision to integrate her substantial legal expertise into her legislative role. Her legal acumen and compelling advocacy style garnered her increased respect within congressional corridors, where her influence expanded rapidly. Where colleagues once regarded her as a mere junior member, many began seeking her advice on intricate legal issues, recognizing her as a reliable and insightful voice on constitutional matters. Her growing prominence was further evidenced by her appointment to key legislative committees, where her presence and expertise became highly valued. She emerged as a trusted authority for Democratic lawmakers grappling with complex constitutional questions, often being called upon to articulate and defend their positions. As her reputation grew, prominent law firms and legal organizations began reaching out, expressing interest in forming partnerships or inviting her to participate in major conferences and seminars. Such invitations underscored the respect she had earned within the legal community and marked her as a rising star with the potential for an influential career beyond Congress. Rumors and speculation soon arose among political circles about her possible future roles at the highest levels of the judiciary or state legal institutions. Conversations about her being a potential nominee for the Supreme Court or a candidate for the position of State Attorney General circulated widely. The very nature of the hearing demonstrated that Crockett possessed both the intellectual rigor to analyze and interpret complex legal principles and the commanding courtroom presence needed to influence judicial proceedings and public opinion about constitutional issues. The exchange involving Crockett and her opponent, Alsup, resonated deeply beyond the legal sphere and penetrated cultural boundaries. The hashtag #CrockettVialup trended on Twitter for 3 consecutive days, sparking widespread discussion and engagement. Memes circulated that humorously celebrated Crockett's poised and articulate dismantling of Alsup's condescending attitude. These images emphasized the stark contrast between Alsup's dismissive laughter and Crockett's calm, evidence-backed rebuttal, portraying her as a symbol of composed resilience in the face of hostility. On platforms like TikTok, content creators produced short videos explaining the legal arguments deployed during the hearing, aiming to make complex constitutional concepts accessible and engaging for younger audiences. These videos serve to educate a new generation about voting rights, judicial interpretation, and the importance of constitutional law, thereby broadening public understanding and interest. Among young lawyers, especially women and individuals from marginalized communities, Crockett's performance and her principled stance became a source of inspiration that motivated many to pursue careers in law, motivated by her example of courage and expertise. Law school application trends from traditionally underrepresented groups saw an uptick, and public defender offices reported renewed interest from recent law graduates encouraged by her advocacy and leadership. Most notably, the hearing transcended its immediate political context and became a pedagogical masterpiece in legal advocacy. For years to come, it would be studied and dissected by law students and legal scholars alike as an exemplar of effective persuasion, meticulous legal reasoning, and strategic use of precedent in high-pressure situations. Many law schools integrated this case into their advocacy training programs, emphasizing lessons such as the importance of thorough preparation, maintaining composure under stress, and employing a well-grounded understanding of constitutional law to sway judicial and legislative opinion. Finally, the general public gained rare insight into the inner workings of voting rights legislation and constitutional interpretation through the vivid narrative of Crockett's systematic and determined efforts to counter judicial dismissiveness. Her clear, logical, and composed approach helped demystify complex legal processes and showcased how individual conviction and skill can influence national discourse. The Crockett-Alsup hearing ultimately came to symbolize a pivotal moment in American legal and political culture. It cast a spotlight on the ongoing tension between entrenched judicial perspectives, rooted in tradition, and innovative approaches advocating for a more adaptable, inclusive understanding of the Constitution. Crockett's remarkable success vividly demonstrated that scholarly rigor, combined with a fresh perspective and strategic advocacy, could challenge even the most deeply ingrained institutional attitudes, paving the way for more dynamic and responsive interpretations of constitutional rights. The recent courtroom hearing ignited a chain of discussions that extended well beyond the immediate legal proceedings, prompting a reevaluation of how judicial training is conducted and emphasizing the vital importance of federal judges maintaining an open-minded attitude toward unconventional or emerging legal theories. Rather than dismissing innovative interpretations outright, the event underscored the necessity for the judiciary to consider new approaches that might better serve the principles of justice and democratic fairness. In that sense, it was a pivotal moment for the broader cause of voting rights, as it lent fresh credibility to evolving perspectives on how the Constitution protects democratic participation. Such moments reaffirm that legal interpretation is not static, but dynamic, capable of adapting to the changing needs and understandings of society.
When Jasmine Crockett walked confidently into Judge Alsup's courtroom, she represented more than just a single legal argument or a particular political stance. She personified the fundamental belief that well-founded ideas, grounded in thorough scholarship and principled reasoning, possess the power to challenge entrenched biases and outdated institutional norms. Her presence and argumentation embodied the conviction that truth and justice can prevail over long-standing prejudices, especially when supported by rigorous preparation and unwavering dedication. The initial reaction of Judge Alsup, who responded with laughter, revealed some of the worst tendencies of an established judicial system, tendencies that often prioritize tradition, protocol, and the status quo over actual justice and progressive thinking. His superficial amusement, perhaps rooted in skepticism or dismissiveness, failed to recognize the significance of her stance. However, his eventual apology and respectful engagement with Crockett's arguments signified a recognition that even the most rigid institutions can undergo subtle but meaningful transitions when faced with well-articulated, thoroughly prepared, and passionately argued perspectives. This shift demonstrated that institutional rigidity is not immutable. With the right mix of conviction and preparedness, even those deeply committed to tradition can be persuaded or at least prompted to reconsider their stance. The hearing's widespread dissemination, capturing the attention of the public across the nation and sparking lively debate, revealed the extraordinary power that dramatic moments in legal settings hold in educating and inspiring millions of Americans. Through this visible exchange, many viewers gained a deeper understanding of voting rights law, constitutional interpretation, and the importance of effective advocacy. Watching Crockett methodically and confidently dismantle Alsup's condescension, the audience saw firsthand how knowledge and principled argumentation can turn the tide against dismissive or prejudiced attitudes. Most critically, the entire exchange reinforced a core American principle. In this country, ideas continue to carry more weight than titles, ranks, or institutional prestige. Preparation and understanding take precedence over presumptive authority or assumptions of superiority. It became clear that one individual, armed with courage, clarity, and unwavering conviction, can effect significant change, influence legal discourse, and foster systemic reform. Jasmine Crockett, who initially entered the courtroom as a relatively unknown freshman member of Congress, left that room recognized as a rising national figure, proof that the emerging generation of American leadership is prepared to challenge the established order when necessary and to defend democratic principles with precision, integrity, and fearless advocacy. The lingering question resulting from this defining moment
does not merely concern whether Crockett's doctrine of living democracy will eventually be enshrined as a formal constitutional doctrine. Early signs suggest that this is highly likely, but more broadly, it raises a crucial point. What other long-held assumptions in American law and politics are ripe for questioning by leaders who blend deep expertise with the courage necessary to stand up against institutional pressures? Her courtroom victory was not just a single legal triumph. It became a symbolic milestone, one that validated her career trajectory and showcased the enduring potential of meticulous preparation, specialized knowledge, and fearless advocacy. Crockett's shining example proved that with sufficient understanding, strategic thinking, and unwavering resolve, even one person can challenge deeply rooted perspectives, influence the course of legal and political debates, and inspire future generations of lawyers, lawmakers, and citizens alike.